Who gets the life insurance? Hi, I'm Darren Findling of the Probate Pro, and this issue of who gets the life insurance after somebody has died is a really interesting question depending on certain fact scenarios. So for example, what happens if there's no named beneficiary? What happens if the beneficiary has died? What happens if the beneficiary is the ex-spouse? And what happens if the named beneficiary is identified but the will says something else? All sorts of unique and interesting issues that can arise following someone's death. We understand that life insurance is a contract, and in that contract, if there's a named beneficiary and that beneficiary is alive, they get the benefits. There's no need for probate. Probate is not needed through the probate court, nor are letters of authority required to obtain the life insurance proceeds. So if there's a named beneficiary, beneficiary controls. Now, if the named beneficiary has died, then of course the secondary or contingent beneficiary would come into play pursuant to the contract. But what happens if there is no named beneficiary? In those circumstances, under most contracts, the life insurance benefits flow to the probate estate, and probate would be required by opening an estate and obtaining a letter of authority. What happens if it's an ex-spouse? Well, under most state laws, including Michigan, upon the death of the individual that has died, no, let's back up a notch. Upon the divorce of the individual, the severance occurs of all life insurance benefits. In addition, the judgment usually provides for that. So there's a severance of those benefits. So the person is treated, meaning the beneficiary, is treated as if they predeceased the person that died, as if it goes then to the second or contingent beneficiary. Now, there are some unique sets of circumstances. For example, if after the divorce, there is a named beneficiary that is completed, or a beneficiary designation that is completed and dated after the divorce, then the beneficiary designation will control, even if it is the ex-spouse. And this happens quite often where people establish a relationship after a divorce, they rekindle their relationship, or maybe if they're raising children together, there's a policy that's put in place to ensure that the children are provided for following the death. And the other scenario that can arise is this very quirky situation in which the benefit of life insurance arose from employment. And ERISA, this is a federal act, governs the benefits. Under those circumstances, there's a conflict of law that exists as to whether state law controls or federal law. We're not going to cover that because that gets quite complicated. Suffice it to say, it's really critical that if you apply and obtain life insurance, that you fill out the beneficiary designation form. And then if you go through any change of life circumstances, for example, a beneficiary has died or you divorce, it's really important to redesignate or confirm the designation of the named beneficiary. And then of course we have this situation where a named beneficiary is identified, but there's a will. And the will gives a residuary or catch-all clause that says, I give everything to the Red Cross, for example. Well, the Red Cross controls in the will, but the contract says they're giving it to their child. Who wins? Under most circumstances in Michigan law, the designated beneficiary as set forth in the contract is going to control that conflict. It's really important when you're addressing these types of issues to work with a skilled, competent probate practitioner that can express to you and explain whether there's a need to open up a probate estate, how to plan for the designations in your beneficiary designations, as well as within your estate plan. If you've got questions about any of these issues, you're welcome to call us at 833-PROBATE or visit us at theprobatepro.com.